Okay, so a question about service really relates to making sure the other side is aware that they've got proceedings before the court and that they have to appear and file documents and attend to what the court's required. So as far as making sure that happens, we often use what's called a process server, which is a professional who serves the documents. They will then produce an affidavit of service, which the court will then accept as being a suitable document to appreciate that the other side knows that they're in court and that there's proceedings afoot. So it's not really a number of times, it's just got to be effective service. And that's usually done through a process server, which is the most reliable way to get it done. So the question for appeals is one that we don't get asked very much, because most of the matters that we deal with, we're a firm that sort of looks at settling matters rather on a basis where everybody gets away with something they can live with. So appeals only happen when one party feels particularly aggrieved by the outcome. So it's very rare for us to work with appeals. That being said, an appeal must be filed within, I think it's 30 days of the order being made. So you haven't got a whole lot of time. You've got to get your act together. The successfulness of them, my understanding is once a judgment is made, it's very hard to have that judgment overturned on appeal unless you've got a pretty good example of an error of law or an error of fact. The error of facts, we try to take care of them within our firm to make sure there are no errors of fact. If there's an error of law, then that's a matter for the counsel, for your barrister, for us to have that discussion and see whether it's worth appealing and whether we can proceed that way. The likelihood of appeal success, not great, but depends on the circumstances. Okay, so this is a question about having orders made and then the other side coming to you to mediate, potentially to change those orders. It doesn't happen often because once orders are made, parties tend to get on with their lives and deal with what they've got. But in that particular circumstances, if both parties agree to change the orders, they can. It has to be done by consent. So if he wants to go to mediation and you agree to go to mediation and you want to change the orders, you can. If you don't want to, then the orders stay in place. And if he wants to change them, he has to make an application to the court to seek the variation of the orders. And that has to be done pursuant to the old Rice-Nasplen test, which is that there is a material change in circumstances. Now, if there has been no change in circumstances since the orders were made, unlikely that that party is going to be successful in changing those orders. But if it's by consent, absolutely, go ahead and change it. If it doesn't suit you and it doesn't suit both of you or doesn't suit the child and you're happy for it to be changed, you can make those orders if everybody agrees.